All right, the hearing is underway in Supreme Court in a very crucial matter. This is about legalization of same-sex marriages. Now, the centre has been insisting that the demand is not inconsistent with the existing definition of family unit in Indian culture. They have said that while they are not invading in anybody's private space, but because it impinges on other policy matters as well, a parliament is a better place to decide on it, not the court. Legalise is now joining us to tell us why exactly is the government insisting that this should be decided in the parliament.
Well, Priya, the government is clear that this is a policy decision. This needs to be within the frameworks of personal laws that are made, and that is in the domain of the parliament, saying that societal ethos need to be looked into while developing such a law, while considering such a law, given the fact that the personal laws will also entail changing of various aspects of marriage in the Special Marriage Act. Now, what is very interesting is that this is a constitutional debate, wherein now the CJI is saying that they are considering invoking Article 145(3) in this case, which basically means the court is considering to hear this matter under a constitutional bench, which is a five-judge constitutional bench. CJI D.Y. Chandrachud is saying...
Stay on with me, Leelashish. We'll come back to you for those details. But right now, Swapnil Kothari, who's a legal expert, joins us on the broadcast. Sir, what do you make of the argument being put forth that SG is saying that a parliament will have to take a call on this matter, not the court, and any interference would cause complete havoc with delicate balance of personal laws and accepted societal values in India?
Well, these are all very high-sounding words used by the Solicitor General to protect the mandate of the government. When Section 377 was read down to decriminalize homosexuality, obviously the next step was that if two people of the same gender can have sex, why can't they get married? It's a logical conclusion. If people want to take a call on getting married, they should be allowed. Just as a heterogeneous couple who lives in together decides to get married or not, it's their choice. Likewise, the same choice should be given to the people who live together. So obviously the Supreme Court, when it hears on 11th April, if it decides to form a constitution bench under Article 145 of, say, five-judge bench, eventually the decision of the Supreme Court will be to allow same-sex marriage. Now, as far as the government's apprehensions are concerned, so-called apprehensions, that the cultural ethos of the country will be ruined, the Indian democracy will be in shambles, the parliament to pass a law is absolutely inappropriate. It's erroneous, because in this country, two people make laws. One is the legislature, which makes the law, then the other one is a judge-made law, which called the decisional law, which is passed by the various courts of the country, including, of course, our apex court, which is the Supreme Court, which under Article 145 is binding on all the courts in the country and all of us, you and me. So if this judgment is passed by the Supreme Court, there is nothing wrong in that. It is constitutionally allowed, and it will have a wider import rather than the legislature making the laws tomorrow. And then again, it will have to go to the court, where some people will say that this is not good, this is unconstitutional, this is not constitutional. So it's better that the petitioner's petition right now is heard on the 11th of April by the Supreme Court, whether it forms a three-judge bench, which is already formed, or forms a higher bench. That's for the court to take a look at it. But eventually, it's better that the Supreme Court passes a judgment on this, as it passed a judgment reading down Section 377 as it, meaning rather as the Delhi High Court passed a judgment reading down Section 377. So likewise, the Supreme Court should take a call on this, because it is of a wider national import, and the petitioners have approached the Supreme Court directly. So why not the Supreme Court should be passing this judgment? And to say also one more argument of the centre, that we should not have Western influences and Western judgments should not be followed. Day in, day out, we lawyers quote the King's Bench, Queen's Bench decisions, English judgments, Australian judgments, US judgments to support our cases. Also, the parliamentary democracy that we follow in this country is borrowed from the United Kingdom. The fundamental rights are borrowed from the US Constitution Bill of Rights. The directive principles are followed from the French Constitution. The emergency powers or the provisions in our Constitution are followed from the German Constitution.
Sir, as you were saying, we've just got details coming from the Supreme Court. They have dictated an interim order, and they are saying that the matter be placed before a constitution bench. What does it mean?
Well, it means that this is a matter of constitutional importance, where several aspects of the Constitution need to be considered, primarily the fundamental rights of Article 14, which is the right to equality. Article 19, right to association, which is you and I, if we are of the same gender, we should have the right to associate. And Article 21, which is right to life and liberty, under the umbrella of which this right to marry also should be included or should be considered. So when you basically, if there is anything, once it passes muster of Article 14, 19 and 21, then it is considered as sacrosanctly constitutional. Now, once that is done, that means that it's better that a constitution bench which looks at the constitutional morality and several aspects of constitution which to allay the apprehensions of the central government, if any, and I believe if many, should I say, because there are many, it seems to be, from their affidavit. So let a constitution bench decide it, because it's a matter of grave constitutional importance whether the same sex should get married and whether we should legalize that kind of a marriage in this country. It's not that we have separate states like in the United States where some states do not allow and some states allow. Here it will be one uniform judgment which everybody in this country, all our 29 states and 7 union territories or 6, whatever they are, will follow. So it's very clear that it's a constitution bench which should decide, and I'm absolutely in agreement with the CJI on that there should be a 5-judge constitution bench, better that way. All our questions, apprehensions should be raised before them.
So,
and let the court decide eventually after hearing both the sides.
So can we decipher from this, sir, that the centre's argument that the parliament should be deciding this has been set aside by the court?
It pretty much is an indication to that effect, that sorry, it's not only you that who will decide. The petitioners have come to us, and it will be extremely inappropriate for us as the Supreme Court to tell the petitioners that, look, this is the domain of the parliament, so please go to them, or please let them do it, because the parliament could do it even after 2 years or 3 years. One doesn't know when the parliament, because the parliament doesn't want anyway the same-sex people to get married. So it will stall this decision of making a law. And why should the Supreme Court not make a ruling? The Supreme Court is fully empowered to hear the side. So let the government state its stand, whatever it is, whether it's agree with it or not is a separate issue.
Right, and whether or not there'll be a rethink on government's stand when it gets to present its case in front of a constitutional bench, which is what the interim order has dictated right now, is going to be a very interesting thing to watch out for. Thank you, sir, for joining me. We take a very quick break.